SJC-12085, Commonwealth versus Buttimer.
Mr. Reardon, good morning.
Good morning, Your Honors. Theodore Reardon on behalf of the defendant, Thomas Buttimer. Your Honors, the first issue presented in this case is that no rational jury could find that the bullet retrieved from the victim in this case had been fired from the rifle possessed by the defendant. The Commonwealth had an expert testify that the bullet in question was a .22 caliber class bullet. The casing in question attributed to the defendant was a .223 caliber. The expert did not elaborate on what it means to be a
Mr. Ray,
Yes.
can I ask, so on the case-in is the .223, and obviously the question that wasn't asked is, what do you mean by .22 caliber class, whether that would encompass a .223? That wasn't asked. So,
Correct.
that's on the Commonwealth. But wasn't the evidence that the .22 recovered from the victim didn't have the typical striations of a bullet that went down the properly chambered round? So he's possessing, the evidence is clear, a larger bore weapon than the .22 that's found in the body. And wouldn't the inference being, because, put the cartridge casing aside, wouldn't the inference being he's carrying this .223 weapon, there's a .22 in her that doesn't have the striations that would be left by firing from a .22 rifle, so therefore you can match one to the other. It's a reasonable inference.
I don't.
But you don't like that math?
I hear you, but I don't think so for two reasons. The first being that the evidence suggests that a .22 caliber class bullet can't be attached to a .223 caliber casing because he testified to the expert.
So put the case in the side.
Yes.
This is a .22 round in her, fired by a larger bore rifle than a .22, right?
Yes.
Do you agree that that was the evidence?
Yes.
With no rifling on it.
With no striations, which
Correct. Yes.
So, and he's got the .223 rifle in his hand. I know, I agree that there's a problem because they didn't ask that magic question about matching that casing to it, but what about the rifle and the fatal bullet?
So if you're asking me, could the jury draw the inference?
Yes.
I would agree that that is a permissible inference just on what you said, yes.
Okay.
Yes.
Okay, thank you.
But
So what does it do you? And let's assume there is this confusion about the casing and the bullet. How does it materially help you?
well, if the bullet was not fired from, the Commonwealth has the defendant linked to the rifle because of the firing pin on the imprint on the casing. But if the Commonwealth can't establish that that bullet was fired from that gun, then the defendant...
Both the defendant's DNA on the lock case in the basement.
Yes, well, and there's no doubt that the defendant possessed that gun. I mean, the officer testified, detective it was pointed at him.
Yeah, so you know, you have the evidence that you have to work with.
Right.
But let's just say that, that there's a point to be made that helps you for a moment about the bullet. In most or many murder cases, you don't necessarily have the gun or necessarily are able to tie the gun to the bullet. In this case, the defendant, shortly after the murder, comes out of the woods. He's got a rifle, and he's trying to shoot a police officer with it shortly after he calls the victim a bitch for throwing him out of the house. That's not so bad. And that's pretty good evidence, separate and distinct from the ballistics.
Well, I think the evidence as to pointing at the gun, at the rifle at the officer is, I mean, that's direct testimony about that he possessed that rifle. But
And pointed the rifle at the police officer and presumably tried to shoot him.
yes,
And said, next time I'll be back with I won't miss or something like that.
yes, and that evidence is what it is. But as far as going back to what happened inside the house, Can the Commonwealth prove that that bullet was physically possible to be attached to the casing that is attributed to the defendant? There's a lack of evidence to that, and the evidence suggests that it couldn't be attached because the expert testified that the .22 caliber ammunition is smaller than .223 caliber ammunition.
So
He
isn't
test-
your argument, your best argument is, okay, the forensics don't work. This isn't a case where there's one gun in the house and one possible perpetrator. The argument is, for you, isn't it, the ballistics don't work, the forensics don't work, and by the way, there's lots of gun in the house, and we also have somebody with a similar motive whose DNA is in interesting places.
Yes.
So
And-
it's the two together, isn't it?
Absolutely, yes. Tying it in with a third-party culprit, yes. And the defendant's blood was not upstairs, but Joseph's, the brother-in-law, his blood was downstairs.
But also, isn't there the .22 caliber bullet retrieved from the victim's body had no rifling, which also suggests that it was fired from from a gun that had bullets that were too small for it, right?
It does, yes. Well, the jury could draw that inference, yes, yes.
I thought the firing pin evidence indicated that it had been fired from the rifle that the defendant was carrying.
No, the firing pin evidence showed that the casing had been fired from that gun.
The casing, I'm
Casing.
sorry.
But
Okay.
there's no evidence that that .22 caliber class bullet could have been attached to a .223 caliber casing.
And if the Commonwealth had a do-over, they would have asked the ballistician, is this .22 caliber class encompass a .223?
Could it be attached? Yes, something along that line. But
Right.
they didn't.
And they didn't.
They didn't.
Right.
And the questions they did ask, again, suggest that they couldn't be attached. By the way, he described the .22 caliber ammunition being smaller than .223, and a .22 caliber.
Yeah, but well, anyway, I mean, so if the evidence, if the question had been asked, this bullet that was extracted from the victim, it's .22 caliber class. What is .22 caliber class? We don't have that.
Right, we don't. Right.
What do we make of the testimony about the .22 caliber class bullets fits within the .223 ammunition?
I'm sorry?
That .22 caliber class bullets could
Yes.
fit within the casing, the .223 casing?
No, that's the point. There wasn't that evidence. There wasn't that evidence.
Okay, it's in the Commonwealth's brief. Let's
That,
see what they have to say.
well, I think you might be referring to where they said that there was evidence so that a .22 caliber ammunition rifle used .22 caliber long rifle ammunition. Is that what you're referring to? Yes. Well, I think that proves the point. Is it shows that a .22 caliber rifle takes .22 caliber ammunition, and that was not a generic statement about all .22 caliber rifles. It was about the other two .22 caliber rifles in the basement. It wasn't as broad-based statement about rifles.
Now, aren't the casings manufactured with the projectile? Don't you just buy them together?
Ammunition, yes, yes,
So we have this mystery.
yes.
And the inference, so you need more than simply a mystery. You need to demonstrate that the evidence is not sufficient as a matter of law.
Yes,
And how does that mystery get you there?
because we don't have affirmative evidence that it could be connected, the bullet and the casing, but we do have evidence from the expert that a .22 caliber ammunition is smaller than .223, and that a .22 caliber rifle can't fire .223 caliber ammunition. The inference to be drawn there is that that .22 caliber class bullet could not have been attached to the .223 caliber casing. And if that's the case, they don't have evidence that the Commonwealth, that the defendant fired this bullet.
And the defendant has in his hands, when the police capture him in the shootout, the .223 rifle that's now smashed,
Yes.
which is another argument you have.
It was not a .223 rifle, it was a
.324,
a 30-40.
Okay, I'm sorry.
It was larger.
Yeah,
Yeah,
yes.
the bigger one.
Which would
yeah.
be consistent with the idea that whatever weapon was used, it had a larger bore area than the ammunition
That was
itself.
the
Yes.
30-40 or whatever it was, right?
30-40, yes.
Okay, I'm sorry.
Yeah.
Okay, thank you.
So, and just one more thing.
Yeah, I'm actually more interested in your second argument, but go
Okay.
ahead. You finish up.
Just one last point about the evidence that did come out was he testified about Sergeant Perkins' handgun, and he said that was a 40 caliber handgun, and it required 40 caliber ammunition. So when he testified about that, the numbers were the same, 40 and 40, 40 caliber gun, 40 caliber ammunition. But here we have a 223 caliber, 22 caliber class bullet and a 223 caliber casing.
Okay, but we still have them coming out of the woods,
We do, and as
aiming at the police officers who are investigating the killing.
yes, yes.
And so does that not give some evidentiary weight to his responsibility for the shooting?
Well, unless they can link that bullet to that gun, which they can't, no.
Well, wasn't the broken stock of the rifle in the, of that very rifle in the basement,
Yes,
which is where the ammunition was?
the casing, yes.
Yeah.
Yes.
So your second issue, do you need to have a functioning firearm to be convicted of armed assault with intent to murder or assault with a dangerous weapon? I found the cases that you both cite a little confusing. Do you want to sort of walk us through the cases that support your position that needs to be a functioning firearm?
Well, on that issue, first of all, that was not an issue at trial. That's something that the Commonwealth has raised for the first time on appeal. And second of all, at least as to the law of the case, the jury was charged per the model jury instructions that it needed to be a functioning firearm. So on both those issues, I don't think it's an issue.
So it's a non-issue because the jury is charged that it has to be a functioning firearm.
Right,
So now in that whole, whether it's fixable easily line of cases?
correct, right.
And in what, so the stock is, and I didn't quite get you know, you have to bend something?
Oh, yes.
Yeah, what was it? How does this operate? to
Well,
get
what
it
the
to
expert
fire?
testified to was that he had to loosen the rear screw at the top tang so that the lever would deactivate the trigger stop. And then he had to straighten the bent tang and tap in a link.
I guess straighten the bent tang is where I lost them. I didn't know I know what bent is, I don't know what tang is.
I don't either.
Okay.
But whatever it was, it wasn't functioning unless that was straightened.
So, and it sounded complicated to me as well. This is the Rhodes case that talks about it having to be an easy fix.
Yes.
But why would this matter for the assault with a dangerous weapon? Put aside the armed assault with intent to murder. The assault dangerous weapon, I mean, does it really matter to that police officer with what appears to be an immediately threatened battery that the defendant thinks he can shoot and the police officer thinks he's dead?
I think as to that issue, the law does not require for that charge, for that count, that they prove it was a functioning firearm. However, on the law of this case, and this is in my reply brief, that the judge charged that in this case, they needed to prove a functioning firearm on that count 11.
Even if he adds an extra element, it has to be satisfied. That's the law. I can never remember the answer to that. So the judge adds an element that shouldn't have been there.
On that count, yes. 11.
And so then so that doesn't give you an extra, something you're not entitled to. You have to satisfy even when he's imposing an extra requirement.
Under the law of the case, yes.
And then the judge gives the instructions, so we have to find it as a matter of law that doesn't fit the properly functioning, easily fixable
Right.
case law, right?
Yes, yes.
Because the ballistician went through the steps, the judge instructed the jury, and the
Yes.
jury so found.
Yes. And as far as the steps that the ballistician went through, it has to be underscored that all the repairs he just mentioned took 30 minutes. But even then, he wasn't confident that it wouldn't explode on him. So he went
Naturally nervous about test firing.
justifiably so. And so he took live ammunition and took out the bullet and the gunpowder and made it essentially a blank and test-fired it with that. And I would suggest to you that's the kind of expertise and effort and whatnot that goes beyond, in the words of the Bartholomew case, quote, a relatively slight repair, replacement, or adjustment.
Am I wrong that this is also the one that had the broken stock?
I'm sorry?
Did this also have a broken stock?
The rifle?
Yeah.
Yes, it did, yes.
And when was it broken?
We don't know, but at some point before he went outside.
But the inference was that he had to smash it to get the improperly chambered
That was the inference the Commonwealth wanted.
Because the,
casing out of it.
Yes.
because the rest of it's in the basement,
Of the stock, yes.
yeah.
Yeah.
Did the broken stock in any way affect the operability of the gun?
There was no testimony to that effect.
Okay.
And just one other thing I would mention also is the third-party culprit, Your Honor. On the evidence in this case, the evidence was that the defendant's hands were swabbed after this incident, and they found the defendant's blood on the hands, which suggests that his hands had not been washed. But they didn't find gunshot residue.
When
On
you
the-
said the defendant's blood on his hands, do you mean Joseph's blood on his hand?
No, it was, no, I mean the defendant, Mr. Buttimer. His own blood was on his hands.
Okay.
Because he had been shot.
I don't know, you know, it was.
But this
there
was after he was shot that they tested his hands.
Well, yes, but I think there was evidence that his blood was in the basement too. So he could have been bleeding beforehand. There was evidence that,
There was no evidence of a struggle, I gather.
no, but the struggle, well, the incident happened on the first floor and the defendant's blood was in the basement.
So this is an absence of GSR on his hands.
In absence of GSR as to him,
Right.
but we have Joseph, who we were saying is the third-party culprit. As to him, he claims that he was asked by the EMTs to go outside and flag down further first responders. But that testimony was not corroborated by the other responders. And he admits that he washed his hands before going outside, and he admitted on the stand that he could have washed away gunshot residue by washing his hands.
But your argument is sufficiency of the evidence on
Yes.
third-party culprit, right? Because this was all played out in front of the jury?
Yes, it was. And the argument is that no rational jury could find the defendant guilty in light of this third-party culprit evidence. Yes. If there are no further questions?
Okay, thank you.
Thank you.
Mr. Kennedy.
Good morning. May it please the court, Nathaniel Kennedy for the Commonwealth, asking you to affirm the defendant's conviction. I think it makes sense to start with the question of the firearm and the bullet.
So
and-
you wish you had the do-over?
Absolutely. I think that question, we're all on the understanding that the next question would have been, does a .22 caliber class projectile fit on the top of a .223 round of ammunition? That question admittedly was not asked. I am arguing that is not fatal to this case in any way, because not only is it just one part of the sufficiency of the evidence, but there are other reasonable inferences that can be drawn that show that that bullet, in fact, was the bullet fired from that shell casing, from that gun held by the defendant. There's one shell casing in the house. There's evidence of one bullet being fired in that house. There's evidence that the shell casing was shot from a firearm that was larger calibered than the shell casing was designed for. And there's also evidence that the bullet recovered from the victim was shot from a gun that was a larger caliber than the bullet was designed for.
Do we know that a .223 is larger than a .22?
.223 is larger than a .22 caliber long rifle. That is a distinction that was made, and that's where I think it's important that the language used by the ballistician was that .22 caliber long rifle, which would be shot out of a .22 caliber rifle, is smaller than .223 ammunition. It's an important distinction.
Say that again.
I'm so sorry, I didn't
Sure.
understand
And
that.
there's a lot of numbers. I know that it's hard to break down, but my brief, I would encourage you to look at the brief, and I do lay it out there. But for argument's sake, the .223 caliber ammunition is larger than .22 caliber long rifle ammunition. .22 caliber long rifle ammunition is what the ammunition designed to be shot from a .22 caliber rifle. The other two rifles in the basement were .22 caliber rifles. So the proper ammunition for those would be .22 caliber long rifle ammunition. There is no evidence that either of those weapons were shot. The only evidence that we have is that a .223 caliber ammunition was shot from a weapon
But that's larger than a .22?
larger than a .22 caliber long rifle ammunition.
So how could he shoot it?
He didn't shoot .22 caliber long rifle ammunition.
Because he fired it from a .32, .40 rifle.
He shot a .223 caliber ammunition.
Just larger than the gun could
So
accommodate?
it's important, I think, just for a quick primer, ammunition is made up of
The whole problem is the description of the bullet out of out of the victim
Yes.
as being 22 caliber class.
Class, and that's the
That's
distinction
the
there.
whole problem.
Class is the important word, and I think that, I mean, that's what I'm hanging my hat on. Class is a broader grouping. There is nothing to say that 22 caliber class projectiles do not belong to multiple different types of ammunition. That's not necessarily explicitly said by the ballistician, but that can be inferred here because he continues to say 22 caliber class projectile belonging to a greater grouping of projectiles.
So a .223 caliber is within a .22 caliber class, right?
That's not in evidence, but that is,
I mean, I understand it's not in evidence, but
that's correct.
that, if we actually had testimony, it would
Yes.
have been that, to
That's
that
correct.
effect.
yes. So I think that it's wrong to say that the evidence shows that 22 caliber class projectiles cannot be attached to .223 ammunition. That is a patently false idea. That is not something that is in the evidence. The evidence is contrary to that. There is no statement that says that .223 ammunition does not have a 22 caliber class projectile attached to it. And again, where the only evidence that we have is that one shell casing was shot, one bullet was shot, and that both of those items were shot from a weapon that was larger caliber than they were designed for, the reasonable inference is that those two things came from the same place.
With respect to the gun repair
Yes.
issue, in your brief, you say, well, this person wasn't an armorer, he's just a regular old ballistician who took 30 minutes. That's kind of a lot, isn't it?
Well, I think it's important that he says he bumbles through. He doesn't know what he's doing. He's not,
he just happens to be a state police ballistician.
he is a ballistician, but he indicated he is not trained in he's not an armorer, nor is he specifically trained in how to fix these rifles. So he had to figure it out himself.
He has to get tools out and put it on a vise.
Simple tools, and that's where I think the distinction lies. It is simple tools, it's a simple fix, where the case law that I cited to,
Wasn't there a firing pin on one case, I believe it is?
Bartholomew is a firing pin, and that's a replacement part, and that's not even what we have here. We don't have a replacement part. And Rhodes is a replacement part. That's the other case that was cited by the defendant. Rhodes is, the ballistician had to strip another firearm, take the pieces from that, and put it on the firearm to make that one work. That's not what we have here.
But at trial, it was tried under the slight repair
It was.
argument, right? So the
It was
le-
tried under the slight repair argument. And as the
But
case...
so Mr. Reardon's reply brief is well taken, that that's the law of the case.
I disagree in that, one, it was raised by the defendant, we're responding to the defendant's brief, but that the law of the case was wrong. And where the law of the case is wrong, it should not then become the law of the Commonwealth, because the case law, or the way that the case was tried was under improper legal reasoning.
Because you've proven that there was an assault and that it was in the context of being pointed at the police officer, a dangerous weapon, and the fact that another element that wasn't necessary to be proved wasn't proved doesn't matter.
That's right.
But I thought that's the okay, I can never keep this one straight without researching it. Is that right, that if you have to prove an element that's unnecessary and you don't prove it, does it matter or does it matter?
I'm not sure I understand your question, Your Honor.
So if the judge, you're saying the judge improperly instructed, added an element.
Added element, yeah.
And there's some ambiguity, there's some doubt whether that, it took a half hour to fix the gun. Does that mean he wins on these arguments?
No, I think,
I mean, say we decide this wasn't easily fixable. Do you win or lose because this element shouldn't have been added?
well, I think there's a couple layers to that. One, if Your Honors are inclined to dispense with my argument that that was never an element that was required in the first place, and place on the Commonwealth the burden of showing operability of a firearm in an armed assault with intent to murder.
I thought you agreed with, I can't remember if it was Justice Gaziano or Justice Lowey's question, that this was the law of the case. The judge made this the law of the case.
The judge did instruct the jury that we needed to prove operability.
And even if that were wrong and he made you prove it and you did not prove it, do you lose or win?
I think we would lose on the two-wit rifle portion, because under the statute 265, section 18B, there's two separate sections. And the section that we proceeded on was essentially a sentencing enhancement for having a rifle.
Assault dangerous weapon with a rifle.
It's an armed assault with intent to murder. 2-wit rifle.
So it doesn't qualify as a rifle
If it doesn't
under
qualify-
Chapter 140.
If it doesn't qualify as a rifle under Chapter 140, then it would go to just straight armed assault with intent to murder, which doesn't have the mandatory minimum of 5 years.
But if this was the murder weapon, can an inference be drawn that it was fired moments before it was aimed at the police officer?
Yes, and that's contained in my brief. That's part of my argument. But also, there is no evidence of when this firearm was damaged to the point where it was no longer operable. There's evidence that Officer Vaness, when he came out of the house after Sergeant Perkins had shot the defendant, he saw the gun next to the defendant, kicked it, and threw it across the yard.
I thought your theory was that they smashed the rifle.
There's also that.
He smashed the rifle to get the casing out.
Yes, there's that, the evidence of that as well. There's an inference to,
Are you saying it could have been from the kick?
could have been from the kick and the throw, could have been from, it's also.
A kick is going to smash the stock of a rifle?
No, the stock of the rifle, I believe, yes, it was probably broken in an attempt to dislodge the shell casing from the rifle. That's true. The stock of the gun, I do not believe, and I think there was testimony, the stock of the gun does not affect its operability. Where it became inoperable in that those tangs were bent, and
Yeah,
that,
where is that in the rifle? What's the trial evidence?
of where those items are, I believe it was being shown to the jury what was going on, so I don't think we have the benefit of seeing specifically what those things he was referring to were, but we don't know when the tang was bent.
Are there photographs?
There are photographs, I believe that they are photographs contained in the defendant's record appendix
Of the broken rifle?
of the rifle itself, and I don't know, it would have been fixed at that point. I don't think there is any, there was evidence presented at trial, yes, but I don't know if your honors have access to.
So we're just gonna, we're gonna have to rely on an oral description of the steps. There was no documentation of what,
I don't think, no, there is, I don't think there was any.
I'm getting confused now, and maybe my colleagues aren't confused, but we've got two things. We've got armed assault with intent to murder and assault with a dangerous weapon, right? And they're based on different victims, right?
Yes.
The armed assault with intent to murder is the, I can't remember which.
Sergeant Perkins.
Police officer.
And the assault with a dangerous weapon is the medic, right?
Yes.
Okay. On both of those counts, the correct law on both of those counts includes or doesn't include an operable firearm. Forget about the law of the case for a second.
The assault with a dangerous weapon instruction did not contain,
Forget about the instructions.
Oh,
I
I'm
just
sorry.
want to understand what the law is. Is armed assault with intent to murder, does the weapon need to function? And assault with a dangerous weapon, do the weapons need to function or not need to function?
well, that's my argument.
I'm not interested in your argument. What is your understanding of the law?
That-
The law on both of those, forget about the law
Not
of the
clear.
case for a second.
It's not clear. It's not clear. There's no case that
Oh, great.
is under Chapter 265, Section 18B, armed assault with intent to murder. There's no case on point that says the Commonwealth is required to prove operability. There's some cases that give guidance, but there's no case that says that.
But the assault dangerous weapon, I mean, I'm sorry to go back to this, there's no way you have to show that it's operable.
Correct. There is a case on point there.
Right, so to ask a question just Kafka asked a while ago that is in a different way. He asked the question, well, what if you have to prove it's an assault with a dangerous weapon and you don't have to prove that it's an operable rifle because there's no enhancement on the assault dangerous weapon, but the judge says you have to prove it. So the question is, it's an OUI case, and the judge says you got to prove operation, public way, impairment, and that the operation was between 7:30 at night and 9:30 at night. And that's what he tells the jury. And they come back guilty, and the evidence in the light most favorable to the Commonwealth is that it was 9:45 at night. What's the verdict?
I apologize, I don't know if I followed you on that.
The judge adds an extra element to operating under the influence.
Right.
The Commonwealth proves beyond a reasonable doubt operation, public way, and impairment, but they don't prove the extra element that shouldn't have been there.
Then I think it should be viewed under what the Commonwealth was required to prove and did prove. And
All right.
When the judge instructed that a rifle is a dangerous weapon in the context of the assault with a dangerous weapon charge, was there any objection by the defendant to that?
I don't believe so, no. No, there was no objection to the instructions.
And so he argues, well, having told them that a rifle is a dangerous weapon, And having been told earlier that they must prove that it was an operable rifle, that the judge essentially had decided the issue which he told the jury they would have to decide.
Yes, but I think that those are he's instructing on two separate offenses, two separate victims, that we oftentimes see throughout any course of a trial where there's charges that are similar to one another. There'll be distinct elements told to the jury that they need to be required to prove, or be required to shown on charge X, and then here's charge Y. And since we have two distinct charges, two distinct victims, he's properly instructing what they believe they're properly instructing on the law of armed assault with intent to murder, and then moving on to assault with a dangerous weapon. So he's properly instructed on both of those.
But I'm confused, and I don't mean to cut the chief off. I'm confused when the chief pointed out, okay, so he's instructed on assault with a dangerous weapon, and he's instructed that the gun was a dangerous weapon. Does he, but does he nonetheless add the instruction that you got to find that the gun is functioning?
He didn't with assault with a dangerous weapon.
He
no.
did not do that with, okay.
There was a few points that I did want to make going back to.
And before you leave that, I gather that whether the weapon is operable depends upon whether it was operable at the time it was pointed.
Not necessarily, no. One of the reasons that I raised in my brief that we don't need to show operability, and this isn't, I'm not trying to go back to my argument, but this is enlightening to that point.
I know that you say it's not required by law, but to the extent that the judge told the jury that's an element of the offense,
Yes.
the relevant moment is not an hour before or 10 minutes after. It's at the time he pointed it at Sergeant Perkins, whether it was an operable firearm. Is that correct?
I don't believe that that's correct.
When would be the appropriate time period, if not that?
At any time that firearm was operable, if that is an operable firearm, if it has not lost the characteristics to make it a firearm. And I think at no point during the course of this entire case did the firearm ever lose its characteristics as a firearm. And that's what the cases tell us. So it's not, and this is why I was going back towards my argument. It's not to belabor my argument, but to inform the court on the theory behind operability is that it shows the defendant's intent. And that's where in the Gordon case I cited in my brief, that's where the court, this is the closest in fact to what we have here, that's where the court required or asked operability be found because it was tied directly to the defendant's intent to murder. So where in that case it was tied to the defendant's intent to murder, it was crucial to be proven so that they could prove the intent to murder. We have more than just the operability of the firearm here to show the intent to murder. We have all the defendant's actions, the manner he conducted himself, him loading the firearm, him stating that I'm coming back with a bigger gun next time. We didn't need the operability at that moment to show the armed assault with intent to murder.
So I know this is a murder case, and you're about 90% of your time on assault with intent and assault with a dangerous weapon. But here's my problem with assault with a dangerous weapon. I understand that the law we don't have a precise case on the armed assault with intent to murder, but it's clear that the assault dangerous weapon, it doesn't have to be a functioning rifle.
That's right.
But the problem is, and the chief alluded to this, that if it's an assault dangerous weapon, if the judge instructs them a rifle is a dangerous weapon, well, it's not dangerous per se if it's not working, and so they have to be charged that even an item that's not a dangerous weapon per se can be a dangerous weapon, and they're never instructed on that. Do you see that problem?
I do see that problem. I don't think we have that here, but I think that one of the cases I cite too is Cephalonis. It's 384 Mass 495. It's actually note 5. And it says that in an assault dangerous weapon case, the Commonwealth does not need to, it was a machine gun in this case. The Commonwealth did not need to show that the machine gun was characterized under Chapter 140, Section 121. So that's settled, or at least that's been determined by the court. But I did want to, if there's no questions on that, I did want to go back to the murder charges a little bit. 2 points I wanted to make. One about the third-party culprit that defendant raises. There is a mistake in my brief, and I want to raise that to the court. I categorize the DNA blood that is attributable to Joseph DeRoche as a palm print. That is not in the record. It is not a palm print. It is a red-brown stain, and I can point the court to trial volume 4, page 175, Dan Pratt's testimony. It's item number 12-1. It's a red-brown stain at the top of the stairs of the basement. That is the only evidence of the defendant's DNA blood being in the house. We have photographs of the defendant's hands being taken, and they were entered into evidence at the police station because not the defendant, the brother and the husband were both taken back to the police station. Their hands were swabbed for GSR, and both of their hands were shown to the jury through photographs. There's no injuries to Joseph's hands that would have been attributable to the blood being deposited in the house. We have no idea when that blood was deposited in the house. So the defendant's pointing to a variety of issues that would have raised a potential third-party culprit. I apologize to use this word, but it's flimsy at best, and it by no means undermines the sufficiency of the Commonwealth's case, whereas we have the ballistics testimony, we have the defendant's intent where he was angry about this note, we have him breaking in, and this is a point that I think on the defendant's argument was missed. The defendant broke into that safe in the basement using a shovel, and his arm reached in to grab the guns. That's inferable from the injuries that that there's blood all over. He cut himself, bled all over the safe, trying to reach those guns. He was down there, tried to get the guns, loaded it with the biggest ammunition that was available in the basement, sat in wait for Norma DeRoche. As she came home, he shot her. He then went back in the basement, fled out the bulkhead, and waited for the police to come. And he was the only one who interfered with the treatment of Norma. When the first responders arrived, Joseph did not interfere with police. John did not interfere with police. They were seen trying to help Norma. The defendant is the only one who tried to intervene and prevent the police from treating the victim as she laid on the stairs. So I think that the evidence of third-party culprit is flimsy at best, does nothing to undermine the sufficiency of the Commonwealth's case. Back to point one, the Commonwealth's case is strong, and it had more than sufficient evidence to show that the defendant was the culprit. So if there are no other questions, I would then rest on my brief. Thank you,
Okay,
Court.
thank you. We'll take our morning break.